Bismillahirrahmanirrahim. Assalamu alaikum warahmatullahi wabarakatuh. A very good afternoon. And my name is Nasir Qadri. On behalf of Legal Forum for Oppressed Voice of Kashmir, I welcome you to our fourth webinar on law of armed conflict and Kashmir. Our webinar mainly focus on the portion of Indian occupied Jammu and Kashmir, which has been illegally annexed by India. So far, in in previous webinars, our experts have successfully reframed Indian atrocities in disputed territory of Jammu and Kashmir as war crimes, crime against the humanity, or a crime of aggression. Uh, just merely labeling them as human rights. But it is very unfortunate that IHL or law of armed conflict has so far remained, it is unable to stymie the effect of armed conflict. As you know, that the excess of the humanitarian or these organization or the operation, it's either it is limited or there is no access to these humanitarian the organizations. Today, Amnesty International has announced that they are just winding up their offices because India has freezed their accounts. So you know what is the situation in India as well as in the hostile conflict of Indian occupied Jammu Kashmir. So although the contemporary international law not only include the statutes and norms to regulate the conduct of state, but also incorporates the instruments to mitigate the destructive conflicts while targeting, it largely falls under the purview of international humanitarian law. So in past webinars, in last webinars, we have heard so many speakers. Dr. Mohammad Mushtaq was there, Mr. Niaz Ahmad Shah from London. He is again an expert on Islamic law and international armed conflict. There were many other speakers. We have heard them that the categorization of the armed conflict in Indian occupied Jammu and Kashmir, the situation of these war crimes or crime against humanity or crime of aggression, or what is the role of judicial institutions when India or Pakistan has not signed the Rome Statute which governs the jurisdiction to the International Criminal Court. So today in our fourth webinar, we have very important and distinguished guests with us. I'll briefly introduce our guests. First of all, let me introduce you with Mr. Sikandar Ahmad Shah. Mr. Sikandar Ahmad Shah is not first, he's advisor also to Legal Forum Kashmir and has also been advised to international humanitarian law perspective. Professor Sikandar Ahmad Shah is a pioneer member of the Sheikh Ahmad Hassan School of Law, LUMS. He has held the visiting faculty position at the Temple Law School, the Wayans State Law School, and the University of Michigan Law School, and holds the position of adjunct faculty at the Maurer School of Law, Indiana. Mr. Shah has served as a legal advisor to the Ministry of Foreign Affairs while he was on the sabbatical in 2012 to 2013. Professor Shah's teaching and research interests are focused on public international law, international human rights law, international humanitarian law, corporate governance, and constitutional designs. Then we have another professor, Professor Sami Yusufzai, if I'm right. So Professor has exposed international humanitarian law. He has his thesis on non-international armed conflict. And then Mr. Professor is teaching international humanitarian law in Bahariya universities. He has taught already. He is teaching international humanitarian law in International Islamic University. Presently, Mr. Sami is as associate professor in state Sharia. What is the full form of that?
Sharia Academy.
Sharia Academy, Pakistan. Sorry. And then we have a third guest, Raja Sajjad, a PhD scholar. He is pursuing his PhD on law of occupation with special reference to the Indian occupied Jammu and Kashmir. And then Mr. Raja Sajjad is Director, Jammu and Kashmir Liberation Cell, Azad Jammu and Kashmir. We have another guest from Africa, a prominent South African, Miss Catherine. She is an environmentalist focused on the climate change, food and water security, and waste management. A social entrepreneur, social justice activist, and human rights defender. Miss Catherine has written for Huffington Post on climate change, politics, and the situation in the Western Sahara. She is an outspoken critic of an action of Moroccan government in the West Sahara, describing the territorial as the last remaining colony in the Africa. She has spoken on the West Sahara as an African state in exile, a cause and the people forgotten. The Mail and the Guardian list Ms. Catherine as one of the 200 young South African in 2014. So we'll be formally starting our session with Professor Sikandar Ahmad Shah. Sir, floor is yours, please.
Thank you, Nasir Saab. I hope everyone can hear me. So, I apologize for the confusion about going first. I unfortunately have a class today, and this is a public international law class with 100 students, so I couldn't get out of that. But I've been tasked today to talk about, in continuing our discussion on two aspects of the Kashmir cause. One is on self-determination, and the other one deals with their status of the freedom movement or the freedom fighters under the law of armed conflict. So I'll start off with the law of self-determination, because that in a way is outside the ambit of, so it engages with IHL law, because at times you can have peaceful, realization of the right of self-determination. In the case of Kashmir, that has not happened. So in this particular case, these rights are intertwined or relate to each other. Because in order to realize the right of self-determination in Kashmir, the only viable solution to me at least seems that they have to move on not just in peaceful ways, but also in arms, through armed struggle. And for that to happen, it's important to realize the legal paradigm of armed struggle, which would be the law of armed conflict, so that we can characterize and understand the ways and methods in which the Kashmiris are fighting Indian occupation. So let me start off with self-determination. Naturally, self-determination is a recognized right under international law and has increasingly become part or crystallized into a customary law norm, international customary norm. The reason why it is still in some sense subservient, or I would say undermined, is because of the law, or the right of sovereignty that each nation or each state possesses, which is the primordial or the most important norm of international law on the basis of which you have the international system. So, and naturally, once a state realizes its independence, then the law of sovereignty is there. But a lot of nation states and a lot of people are under occupation, and so the law of sovereignty is oftentimes used, as has India and is using, to undermine the cause of the Kashmiri freedom struggle, a right that is recognized not just under customary law, but also through various UN General Assembly resolutions, which I will discuss quickly, as well as Security Council resolutions under Chapter 6, and subsequently, as recognized by the majority of the world community. I think there's no doubt about it that the Kashmiris have a right of self-determination. So anyway, just so that, because I am a lawyer, I would like to talk quickly about the law, and I want to spend equal times on both subjects, and I think I have 15 minutes. The UN Charter, which now reflects customary international law in all its forms, mentions the right of self-determination and under Article 1, actually, the first article, which recognizes this right of the self-determination of people. However, it doesn't define it. So the definition comes later under the, a more of a definition. I mean, recognizing itself is a way of defining something, but it is defined under the common Article 1 of both the International Covenant of Civil and Political Rights and International Covenant of Socio-Economic and Cultural Rights, both now customary international law, both a binding. It wasn't a binding instrument. It wasn't a treaty in the real sense. It was just something At that time, that was just an arrangement, an agreement, a soft form of international law, which eventually crystallized through these two conventions. And these conventions in detail discuss and their interpretation actually, that people are within their right, have an inalienable right to define or determine their political status and freely pursue their economic, social, and cultural development, and sort of use their own natural resources, which in the case of Kashmir, as we know, has not happened. Economic resources are exploited, political rights are exploited, both from a external self-determination purpose, but also from an internal self-determination purpose. I raise that because while in the case of Kashmir, both are applicable, but one is, but we cannot, without prejudice to the argument that the Kashmiris have a right of self-determination, which is that, that right is established. Even if it wasn't established, this is how lawyers work, without prejudice to that right, there is what is called the right of internal self-determination, which is that all people living under control of a particular country or a state have to have access to those basic universal human rights. And if those rights are undermined, then that right of internal self-determination eventually graduates to the right of external self-determination. So the argument would be, even if Kashmiris didn't have the right of external self-determination, at this point in time, that right has materialized. The right of self-determination is also discussed under Article 55 of the UN Charter, which is about the promotion of certain rights like standard of living, employment, economic and social progress and development, cultural rights, education, and respect for human rights, and no distinction based on race, sex, language, and religion. So in that context, also the right of self-determination is recognized. Moving forward, the right is recognized under customary law, which also is reflected through General Assembly resolutions on self-determination. The most prominent being GRS 2625, the Declaration on Principle of International Concerning Friendly Relations and Cooperation Among States, that clearly lists and recognizes the right of self-determination. And in this context, the right to an armed struggle is also recognized. And so our GA Resolution 1512, 1541, 2625 are some prominent General Assembly resolutions that discuss this right. The right is also discussed in numerous ICJ judgments, including the advisory opinion on Namibia, West Africa. So one is Namibia, 71, West Africa, 75. A case concerning the frontier dispute, Burkina Faso, Republic of Mali, and East Timor case, Portugal versus Australia. And in this case, the Portugal versus Australia case, this right is, because it's a recent judgment, is one of the essential principles of customary international law, and I'm quoting this. So it's being recognized as a customary norm is now pretty much established. So previously I discussed more in our discussions self-determination in the context of UN resolutions. We don't need to discuss that. UN law, I wanted to discuss other, we did discuss GA resolutions and the UN Charter, but I guess we've discussed particularly specifically how this right is relevant to Kashmir, but I wanted to also contextualize it in the broader context of the law of self-determination. And I don't want to go over, because we have on numerous occasions, the right of self-determination as applicable to Kashmir, as recognized under Security Council resolutions, because India itself is the country that took this matter to the UN. And as we know, that particular chapter deals with the Pacific settlements of disputes, and that never happened. So now moving forward quickly before I discuss the law of armed conflict, with regards to self-determination, again, without prejudice to the right of Kashmiris as established under both the UN Charter, customary law, GA resolutions, and SC resolutions. Recently, and I mentioned this because the right of self-determination has been further undermined by Indian actions through revocation of certain constitutional provisions that we are all aware of. This is further taking away the right. It further takes Kashmir away from realizing the right of self-determination. It's in violation of if we were to even accept the instrument of accession, because the instrument of accession was based on certain freedoms and autonomy granted to the Kashmiris, even if you were an Indian. I mean, that's what I'm saying. For us and the Kashmiris, I would think for whoever is a human rights activist and an international lawyer who sees things as objectively as they can be, it's an established right from the start. But even if you were to go along with the instrument of accession, it's a direct violation of the instrument of accession. So that arrangement itself is null and void. And also, subsequently, the arrangements with Kashmiri leaders that were pro-India, even those arrangements are now being reneged. So we are moving away from what India had actually is claiming or has claimed that they had agreed to, and also from the Shimla Declaration, which talks about not changing the status quo in any way. Moving to armed conflict, the question is: are Kashmiri fighters, can they avail of these protections? Definitely. Because I don't know how much time I have, but just quickly, because I know I only have 15 minutes. An occupation is defined under Common Article 2 of the Geneva Conventions. And in itself, if you go even further in time, you'll see the more detailed definition is in Article 42 of the Hague Convention of 1907. If I was to just quote, this territory is considered occupied when it is actually placed under the authority of the hostile army. The occupation extends only to the territory where such authority has been established and can be exercised. So the occupation is in Indian occupied Kashmir. This was attached to the 4th Geneva Convention of 1907. So we have the 1948 Geneva Convention. I'm talking about Hague law. And so while India hasn't ratified or signed this 4th Geneva Convention of 1907, it is now considered customary international law. So India is in violation of occupation law. Also, in terms of crimes that we've discussed, there are numerous war crimes that India is systematically and historically committing on occupied territories, like rape, the Kunan Posh Para incident, which has been established that rape is under the ICTY case of B.R. Dunin. If I'm not pronouncing it properly, I apologize. It's not my language. And so in the context of an armed conflict, it would be considered a war crime. People argue, or India argues, that Kashmiris are not combatants in the real sense, because only in international armed conflict do you have combatants. I think that's an incorrect rendition of the situation. First of all, Kashmir is not a territory of India to start off with. It was a princely estate, and its right to join one or the other nation, and in my view, to be independent, was established by the Security Council, and continues to remain as such. So it's not a situation where you have what would be a purely non-international armed conflict, where there is some discussion on states, for states, to not define combatants as combatants, but as organized armed groups, or like even what India does, terrorist organizations. In any case, even if you were to have a more objective understanding of IHL law, it shouldn't make any difference, because a lot of what is AP1, Additional Protocol 1, and Additional Protocol 2 applies to non-international armed conflict. AP1 applies to international armed conflict, and a lot of the definitions are coming from AP1 are now considered customary international law, even though both India and Pakistan have not signed AP1 or AP2, as far as I understand. In terms of domestic law, also there's various understandings of what are combatants. Why it's important, because combatants have privileges, and civilians who partake in hostilities, DPH, those privileges might not be available to them in terms of fighting, but the protections are also different. Sami Saab would be able to more detail this more, because he has more experience on working on these issues. But I would like to just start the discussion by pointing out that if you look at the UN General Assembly, they don't really make these distinctions. In a 1970 General Assembly resolution, the General Assembly speaks of combatants in all armed conflicts. So combatant is defined, as far as I understand, by organization and complying with the laws of war, which is IHL, which Kashmiri fighters and combatants are. I mean, and I last time also I discussed this, that when they target Indian forces, they proportionally target them. They don't use unnecessary force. Whatever weaponry they have available, they use them. They don't target civilians like the Kashmiris do. I mean to say the Indian army does. They also do not use any banned weapons, which the Indian army uses in terms of pellet guns. And they distinguish between combatants and civilians by targeting Indian armed forces, whereas there are numerous cases of India targeting civilians on a regular basis. So there is no reason to basically not and I think it's something. I mean, so to basically take away the status of Kashmiri fighters as not being combatants, Pakistan also needs to use the right. It's also a battle of narratives. The right language, in some sense, that has happened in terms of how Pakistan moved forward with how Pakistani maps have been defined. But in terms of calling Kashmiri fighters as combatants and using language of international humanitarian law, of occupation, of belligerent occupation, of the right of self-defense of the Kashmiri, of the right of using force to realize the right of self-defense, which is ad bellum law, which is how you use force in the first place, which is self-defense. And then using IHL language and the narrative of IHL that Kashmiri fighters, combatants comply with laws of war. Their use of force is proportionally necessary. They do not use banned weapons, and they do not cause unnecessary suffering, and they use force for when it's military necessity, which is defined under Geneva Conventions and the AP additional protocols to the Geneva Conventions. When there is a military target, you can target them. And I mean, I have a definition here, but I think I'm out of time. But it is, the capture and destruction or neutralization of military assets and fighting with military, armed forces with the objective of gaining a definite military advantage. There's nothing illegal when you fight for realizing your right of self-determination. So let me stop there. I unfortunately have to leave. So if there are any questions, I could be asked those right now. But if that would disrupt the schedule of discussion, then I would beg leave, and hopefully I will be able to contribute in another way through maybe sending emails if there are questions.
Thank you very much, Professor Sikandar Shah, for your valuable comments and then giving the exposition of certain things. I request if anyone has question quickly, or it can be we can email your questions, inshallah.
I have 5 minutes. So if anyone has questions, otherwise I'm more than please feel welcome to email questions and I will respond.
Yes. But if any questions to Mr. Sikandar Shah, you can email or text him. So without taking you much time, I request Mr. Professor Sami. Sir, the floor is yours, please.
Bismillah wa salatu wa salam ala Rasulillah. Can you hear me, Raja Sahab? Nasir? मेरी आवाज आ रही है?
Gigi, you're audible. Yes, please.
Okay, perfect. Thank you so much, Nasir Qadri, who remained my student in LLM International Law at the Islamic University, Islamabad. I'm very thankful to you for inviting me to this prestigious forum, LFOVK. And of course, I'm very happy to see my learned colleague, Professor Sikandar Ahmad Shah from LUMS after a long time. Raja Sajjad Saab is very kind towards Nasir Qadri and LFOVK for coming all the way again and again for these discussions on the conflict situation and Kashmir. Um, First of all, I would I have prepared my plan as mentioned by Nasir Qadri and Sikandar Ahmed Shah Saab a while ago, that this conflict, the nature of this conflict in Kashmir is occupation, and the law of occupation is to be applicable to that armed conflict which is ongoing in Kashmir. But for me, I cannot, of course, differ with my learned teacher and mentor, Professor Dr. Mushtaq Ahmed, Director General Sharia Academy, International Islamic University, Islamabad. But I have something different in my mind to ease the difficulties of Kashmiri people who are suffering this from last 70 years or more than that, even since 1948. They are suffering these atrocities from the Indian forces, military and paramilitary forces, of course. So I just wanted to drag the attention of this forum and all the people who are hearing towards the issue of the classification of the conflict. So if we say this is occupation, of course, occupation is an issue of international armed conflict, and all the bulky Geneva Conventions and additional protocols and customary humanitarian law and international criminal law and all its ways and will be applicable to the situation if we classify it as occupation. For me to ease the difficulties of the Kashmiri people and give them the bare minimum safeguards and safeties available under international humanitarian law under the law of the armed conflict, that would be the classification of this conflict as non-international armed conflict. As we know that international humanitarian law is only applicable to conflict situations, whether that conflict is of international character or that is of non-international character. But the legal regime for these two types of conflicts is different then. And that is because we say that in international armed conflict, you have to apply if there is an armed conflict between two or more than two states. All the four Geneva Conventions, along with its additional protocol 1, as just mentioned by Professor Sikandar as well. Additional protocol 1, Hague law, which is related to the means and methods of warfare, what to use and what not to use are, let's say it in another phrase, that there is no choice of your own for choosing and picking up arms against your enemies. So that is regulated by the Hague law. And of course, international criminal law would be applicable to international armed conflict in its full form. That application and making India convincing them about application of this bulky law is next to impossible. But what we can do is to convince the Indian government to at least give the Kashmiris the fundamental guarantees being provided in Common Article 3 to the 4 Geneva Conventions, Additional Protocol 2, and the customary international humanitarian law, some of the rules. I have written my thesis back in 2010 on this issue, the law of non-international armed conflict. And from there, I would like Common Article 3 is quite common, and it is known as the mini convention as well, because it's a lengthy article, and it provides so many guarantees to the people who are fighting within a state territory are, let's say, non-international armed conflicts. For example, there are four bare minimum guarantees available to everyone, and that is, written in the article itself. Number one, violence to life and person, in particular, murder of all kinds, mutilation, cruel treatment, and torture. This is prohibited under Common Article 3. So India is violating the life of people, killing them, murdering them, mutilating them, and of course, if they are in some internment centers, if some people, the freedom fighters, have been arrested, they are being treated cruelly and inhumanely, and they are also being tortured. So torture is an issue of human rights law. It is an issue of humanitarian law equally. So one cannot deny this prohibition to anyone. So if we are simply saying that the conflict of Kashmir should be considered as non-international armed conflict, then the Indian forces, the Indian government is responsible to prohibit its soldiers from committing violence to life and person. Second guarantee which is available in Common Article 3 is the taking of hostages. So you cannot take hostage. You cannot take a person as a hostage for your own purposes. Then third one is outrages upon personal dignity, in particular humiliating and degrading treatment. So degrading or humiliating treatment is a prohibited thing which is being declared as prohibited in Common Article 3. The fourth one is related to some judicial guarantees, and we had this discussion in the previous seminar or webinar with Professor Dr. Muhammad Mushtaq Ahmed, and he mentioned about the process and procedure of going to the ICC, prosecuting the war criminals which they have committed in Indian occupied Kashmir, etc., etc. So this is one of the fundamental guarantee which is available under Common Article 3 of the 4 Geneva Conventions, which says the passing of sentences and carrying out of executions without previous judgment pronounced by a regularly constituted court, affording all the judicial guarantees which are recognized as indispensable by civilized people. So ये guarantees हैं जो आपको, और इसके अलावा भी, if you people have time, and I should encourage all of you that you go and read Common Article 3. You will love each and every phrase of the article itself. जब हम इसकी बात करते हैं application of international humanitarian law or application of Common Article 3 to the Geneva Conventions, then we are simultaneously, we are supposed to talk about, for example, I'm not talking about Edition Protocol 2 because India has not signed, ratified Edition Protocol 2. And as it is quite famous in the Bush administration, Donald Rumsfeld and Condoleezza Rice, they would call this Edition Protocol 2 as the Bible of terrorists. So I don't know why they were calling it the Bible of terrorists, but as far as I understand, because they were calling it Bible of terrorists because there are so many guarantees available to the belligerents or the insurgents who are fighting against their governments are within the territory of one state. So if they have not signed the treaty, if they have not signed the Edition Protocol, the international community cannot insist to implement whatever has been guaranteed in Edition Protocol. That is a legal hurdle for us. But there is another way out for that application of those fundamental guarantees, and that way out is the application of customary international humanitarian law. So customary international humanitarian law is applicable to each and every situation, whether that is of international conflict, whether that is non-international armed conflict. And each and every situation, the rules of customary international humanitarian law has to be implemented in letter and spirit. So some of the fundamental rules being identified in customary international humanitarian law, which the Indian government, the Indian forces are supposed to, and they are obliged to follow these rules. I'm just giving you 10 of them. I'm not going to explain it in detail. They are self-explanatory. Some is like the repetition of whatever has been mentioned in Common Article 3. Some of them are mentioned in Additional Protocol 2. And if some are not mentioned, they are mentioned here. So civilian and Hardy-Comba must be treated humanely. So civilians and Hardy-Comba are those fighters who are no longer fighting due to their illness, their imprisonment, their surrender, etc., etc. किसी भी वजह से they are no more fighting, so they are considered, they are known as Hardy-Comba in international humanitarian law. So they and civilians, both of these two categories are to be treated humanely. And this is Rule 90 of the customary international humanitarian law. Rule 93 says that torture, cruel, or inhumane treatment and outrages upon personal dignity, in particular humiliating and degrading treatment, are prohibited. So this is what we just mentioned in Common Article 3. Rape and other forms of sexual violence are prohibited, as mentioned by Professor Sikandar Ahmed Shah a while ago. That rape is one kind of a battle, a method, a means of warfare, which should be, of course, stopped. And there are thousands of incidents of rape in Indian occupied Kashmir, which is, of course, prohibited. And this is the violation of the customary international humanitarian law. Enforced disappearance is prohibited. This is mentioned in Rule 98 of the customary international humanitarian law. So enforced disappearances, we all know that Indian occupied Kashmiri people, they are suffering this type of disappearances on daily basis, which should stop and which should end. Fifth guarantee, which is available to each and everyone under customary international humanitarian law, is the arbitrary deprivation of liberty is prohibited. Sixth one is no one may be convicted or sentenced except pursuant to fair trial, affording all necessary judicial guarantees. And we know that no such fair judicial guarantee is available to anyone living and residing in the Indian occupied Kashmir. Seventh guarantee is that the convictions and religious practices of civilians and persons Hardy-Comba must be respected. So you cannot
They are like the
ask.
gold. So the
Summons, he gets done, throws the fucking summons right through the fucking window.
Hello,
Have
sir.
a nice
Hello,
day, Mr.
sir.
Malone. Go. I mean,
Hello, sir. Wait, hello. Hello, sir.
what he did.
Hello. Hello, sir. Riaz leaked it on
Are
Twitter,
you,
sir. Riaz leaked it on Twitter, sir. Your ID.
please carry on. Please, it has been hacked. It's again, the how Indians are actually hampering the process. I'm extremely sorry.
Myself. Yes, okay, Nasir. So it's all right, no worries. I mean, this is what could we expect, the minimum, huh? Because we are
Inshallah.
asking them to give us minimum guarantees for our Kashmiri brothers and sisters. Okay, the eighth fundamental guarantee available in customary international humanitarian law is that mutilation, medical or scientific experiments or any other procedure not indicated by the state of health of the person concerned and not consistent with generally accepted medical standards are prohibited. So there could not be like people are being taken, they are being disappeared, and then some of them are being experienced, they are being exposed to some medical and scientific experiments which are not according to the humanity. Ninth one is that uncompensated or abusive forced labor is prohibited. So the detaining power cannot ask you for such forced labor which is uncompensated. So if you are doing some labor, you have to be compensated. This is being guaranteed by customary law related to the armed conflict. The 10th one is that hostage taking is prohibited, which is of course the repetition of what we just mentioned in Common Article 3. Similarly, Article 75 of the Edisha Protocol 1, of course, Edisha Protocol 1 again is not signed by the Indian government. So even if we say they have not signed Edisha Protocol 1, but the fundamental guarantees identified in Article 75 are the repetition of Rule 90 to Rule 103. So there are 13 or 14 rules related to the protection of people who are not fighting or who are the civilian population. So some of those guarantees I would quickly go through it. An accused shall be guaranteed all necessary rights and means of defense. So if someone has been taken away by the forces, he or she must be given proper means of defense. So he or she should defend him or herself. A person can be convicted only on the basis of individual criminal responsibility. That is a bit, vast application or vast interpretation of what we have mentioned in the rules of CIHL and Common Article 3. An accused is presumed innocent until proved guilty according to the law. So Article 75 of Edisha Protocol 1 gives you this guarantee as well. I just like the way Professor Sikandar Ahmed Shah mentioned about the use of weapons and all that stuff, which I'll a bit connect with some legal regime as well. Hague Regulation 4, Article 1, Sub-Article 4 describes the features of a combatant. So there are four features or four elements which someone if fulfills, he or she could be considered as combatant. But there is a bit technical issue related to the status of combatant in international armed conflict and non-international armed conflict. But the baseline remains the same, that the baseline of this law is humanity, so humanity shall prevail in each and every circumstance. Therefore, application of the combatant status to in international armed conflict confers upon you the right to be considered as prisoner of war, which is of course a prestigious status, and that has been protected under Geneva Convention 3 of 1949. But if you are fighting, you are a insurgent, you are a belligerent, you are being caught, so there is no status of POW, because Geneva Convention 3 only applicable to international armed conflicts. So you would not be considered as a POW, but of course you will be considered maybe as an intern or as whatever you call it. I mean, I don't know. So for that purpose, the four criterion being set out in Hague regulations is that you carry arms openly, you are under a responsible command, you carry you wear a weapon, or you have an emblem, like a distinctive emblem, which makes you distinguished from civilians. Like, so you are not considered as a civilian person. And the fourth and the foremost important one is that you obey the rules and regulations of the law of warfare, which means you are following the rules of international humanitarian law. So if you are fulfilling these four conditions, you are considered as a combatant. So here, what I want to connect is to obey the rules and regulations of warfare. So Kashmiri people, if they are fighting with the Indian forces, the Kashmiris have never used the banned weapons. The Kashmiris have never attacked any civilian population. The Kashmiris have never committed atrocities against the opponent army. The Kashmiris have never taken the members of the armed forces of Indian army to some prison camps and tortured them. I have like never seen it on media, and I have never seen any report which say that the Kashmiri fighters, they have taken the Indian forces to some camps and they are being tortured. No, I have not heard such things. So basically, what we need to do in the contemporary situation is to pursue our case in a way that we should demand that India shall give us the bare minimum fundamental guarantees to the Kashmiri population, and that's how we would further move towards getting more and more and more benefits from the current legal regime applicable to the conflict situation in Kashmir. I thank you very much, all of you, for your kind patience and listening to me. Thank you.
Thank you very much, Professor Sami, for distinguishing between the combined and non-combat force under IHL. To continue this series webinar, I request Raja Sajjad Khan to tell us about the law of occupation and a case study between a law of occupation akin to the situation of the West Bank occupation in the Palestine. Sir, floor is yours.
बिस्मिल्लाहिर्रहमानिर्रहीम। आवाज आ रही है?
जी जी
जी आवाज आ रही है।
Thanks Nasir Qadri Saab and Legal Forum for Oppressed Voices of Kashmir for arranging this session. Actually, I was thinking that I should speak before Dr. Sikandar Shah Saab and Sami Saab, because these both are expert in international law, and I think that I am just a student and exploring the different legal aspects of Kashmir conflict. I will not go into the detail of international armed conflict and international law because Dr. Saab and Sami Saab had already discussed in detail the application of international law on Kashmir. From last 70 years, we have changed our narratives constantly. Even we are changing our legal phrases and terminologies, and that have changed all the context of this Kashmir conflict. The second observation is that we should understand as a nation that in legal warfare, the prime objective of our efforts should be the internationalization of this case in true legal context. We should not think about the winning or losing of this case because at legal floras or legal forms, we cannot get the decision that whether the Kashmir belongs to Pakistan or Kashmir belongs to Kashmiris or it is the Indian Kashmir. So we should keep in mind these legal implications and the legal output of our effort. When we say that Kashmir is international armed conflict, and there are two dimensions of this conflict. First, it is a conflict between India and Pakistan. The armies of both the countries are on ceasefire line. Unprovoked shelling causing loss of lives and property on daily basis. In this dimension, it is not only an international armed conflict, but it is also a threat to peace and stability of the world. The second dimension of the Kashmir conflict is the Indian occupied Jammu and Kashmir, where people are struggling against foreign occupation. This struggle is indigenous and for achieving the right to self-determination. On political front, joint resistance leadership is leading this movement, and Mutahida Jihad Council is an umbrella organization of all armed groups in Indian occupied Jammu and Kashmir. Two recent reports of United Nations Commissioner for Human Rights and several reports of Amnesty International, Human Rights Watch, Doctors Without Borders, Jammu and Kashmir Coalition for Civil Societies, and other national and international organizations shows that Indian forces are committing war crimes, crimes against humanity, genocide, and grave breaches of international humanitarian law. The customary international law, as Sami Saab has discussed, and 4th Geneva Convention and its additional Protocol 1 declares this situation as international armed conflict. I will not go into the detail of provisions of those conventions. The advisory opinion of International Court of Justice on construction of wall in occupied Palestinian area is ipso facto applicable on the situation of Jammu and Kashmir. I will suggest some way forward for for government of Pakistan and government of Azad Jammu and Kashmir. First, Pakistan should develop the case as the struggle of people of Kashmir against the military occupation of India. For this purpose, Pakistan should provide political, diplomatic, and logistic support to people of Jammu and Kashmir to pursue this case. Second, right to self-determination of the people of Kashmir is another aspect of this case, and this should also be projected by the people of Jammu and Kashmir. Third, after 5th August, the role of Azad Jammu and Kashmir government has been increased because it is the only government who is representing the people of Jammu and Kashmir. When we see the situation of Indian occupied Kashmir after 5th August actions, that government is the government of Indian occupied Jammu and Kashmir is not representing the people of state of Jammu and Kashmir, and that is the government of Union Territory, which is nominated by the Indian government, and so the government of Azad Jammu and Kashmir is the only government that represents the whole state of Jammu and Kashmir. And this government should lead the campaign, and Pakistan should provide the assistance to this government. Pakistan should also analyze the international conventions in Kashmir context and international situation, the internal situation of Pakistan for ratification to invoke the jurisdiction of international legal forms. When we discussed that in which form we should go for human rights violation in Indian occupied Jammu and Kashmir, or we should go against genocide, the basic problem is for Pakistan is the ratification of those conventions. So we should analyze and discuss its political and legal implications for ratification of different conventions and charters. Kashmiri diaspora should be supported to invoke the law of universal jurisdiction. As you all know that the law of universal jurisdiction is applicable in Belgium as well as in UK, and there are many cases of human rights violation in Indian occupied Kashmir that are reported and well documented, and the affectees, the family member of those affectees are living in UK or Brussels, they can invoke the universal jurisdiction law there. So we should prepare a case on that grounds also. The next suggestion is we are only focusing on the political forums, and we should establish legal as well as academic forums for the projection of this Kashmir cause. Another important aspect of this conflict is the legal expert and research scholars should analyze the model of Northern Turkish separatists and Moro National Liberation Army. Both have an observer status in OIC, and we should analyze these two cases with the case of Azad Kashmir government and Muttahida Jat Council. And how can we project these two governments in line with these two forums, and whether it is in the interest of the people of Jammu and Kashmir and in the interest of Pakistan or not. So we should analyze that. Pakistan should announce its withdrawal from Shimla Agreement, as India is continuously violating this, and not only Shimla Agreement, but India is violating all the bilateral agreement. So we should come out from that. We are debating that in Shimla Agreement, there is a provision that all the issues will be settled through under UN Charter, and we are also saying that Article 103 of UN Charter is saying this. But India had marketed its case of bilateralism, and the international community is convinced that the issue of Kashmir should be resolved bilaterally according to Shimla Agreement. So it's a time, and after 5th August 2019, I think that immediately Pakistan should announce the withdrawal from this Shimla Agreement, so that we can internationalize this case in international forums. And other important thing is there is a need of coordination among all geographical entities of state of Jammu and Kashmir and Kashmiri diaspora, because without coordinated effort and well-planned effort, we are not in a position to expose the India at political and legal forum. So these are my some suggestions for further research, for further discussion, because we all are convinced that Kashmir is international armed conflict. We all are convinced that India has occupied the state of Jammu and Kashmir. There is many provisions, international jurisprudence on the law of occupation, that occupational forces are countries had no legal right of sovereignty on that occupied area. But we first of all we should frame this case and establish this case on these legal ground, and then we will be in position to invoke the jurisdiction of international legal forums. So these are my humble suggestions, and thank you very much, Nasir Qadri Saab and the listeners. Thank you so much.
Thank you very much, Raja Sajasa, for giving an insight on the law of occupation. How Kashmir, we believe that Kashmir is not only illegally occupied, but as per the Security Council, I remember, and I'll repeat, the Kashmir is now a case of a modern occupation, a prolonged occupation in the modern history. If Israel's 18 years in Palestine would amount to prolonged occupation, so if you take the case akin to the situation where everything is akin, similar to the Palestinian occupation, that it becomes the prolonged occupation in the modern history. Now, I request our final guest speaker, Miss Catherine. Miss Catherine, floor is yours, please.
Thank you so much. Firstly, I would like to just thank all of the speakers for their inputs and their really important, informative discussion that we have had over this past hour. I will keep my comments quite short and brief, and just say that I really think, as an activist, I came to Azad Jammu Kashmir exactly a year ago, and coming from a country like South Africa, our history, a very dark and evil past of history. And I think it's important to know that a history such as ours means that we look back, and as a young democracy of only 25 years, we have to analyze where have we come from, where are countries such as, territories such as Kashmir, Western Sahara, what are the lessons that can be learned from South Africa? Currently, we see this evil occupation of Kashmir happening. We see the lockdown, which has been over 1 year, where the media blockade has happened, where the violent lockdown on Kashmiri people has seen so many people lose their lives. We have seen people not being able to connect with their families, having no idea what is going on either. I think that coming from a country like South Africa, on a continent of Africa where there are so many different kinds of conflicts, but only one colony, which is the colony of Western Sahara, under military occupation by Morocco, we see that the United Nations has not only been the only body that can serve us and can give us the answers that we need. As an activist, the contribution that I would like to make today is that we have to fight to continue keeping the issues such as the Kashmiri issue, the question of Western Sahara, the issue of Palestine, and many others. We need to keep them on the agenda. We need to ensure that conversations and debates like this, forums such as these happening today, need to continue to happen on a vast platform and on a continual basis. We need to make sure that awareness and education are a priority, continuing to educate and create awareness of what is the issue of Kashmir. We understand that the media globally is controlled by an elite few who are trying to ensure that the world only understands what they want them to know. So therefore, the Kashmiri issue is then not gone out and about on global networks and platforms. It is given very minimal mainstream media coverage and publicity. We need grassroots level organizations, the academics. We need social movements and bodies, not only in countries such as Pakistan, countries around the region where you live, but regions around the world, to continue to talk about the issue of Kashmir. 5 years ago, I started to work at the United Nations Human Rights Council, specifically working on the illegal occupation and the fight for self-determination of the Sahrawi people of Western Sahara. And it was there that I first came into contact with Kashmiri activists and the conflict in Kashmir. Understanding the Indian occupied Kashmir and what is going on behind the black curtain that we don't see, the violations of human rights, the torture, understanding very, very specifically the mutilation, the torture, the rape of women and children is something that horrified me. It horrified me because far down south on the other tip of Africa, in South Africa where I come from, this is not an issue that is brought to the fore. It is not something that we continually talk about or even hear about. And so minimal information is known about this specific conflict. And so I would urge those who are participating in today's discussion, those that will watch this video thereafter, I would really encourage you to not only share the information that you have taken away from today, but continue to share it in a way that you can educate your own communities. Social media and technology has allowed us, I'm on the other end of the world and I'm able to be on this platform with you. And as an activist, I can say that we need to be able to not only be doing things through the channels of what we need to fight for through the United Nations. We must not only work as academics in a certain silo, we need to cross-reference all the work that we're doing. And we need to broaden the understanding of the issue of Kashmir far across different spectrums of people, social community organizations around the world need to start talking about the illegal occupations that still exist in the year 2020. It cannot be that in the year 2020, torture, murder, rape, mutilation continues to happen on our watch. We see ourselves as such a forward-moving human race, and yet we are destroying the lives of people every single day. But they're not, they go by unknown. Names of people who die, Kashmiri people who die, go unknown to the world. It cannot be that the global media agenda is only about what serves a few and those that have money and power. We cannot allow global powerhouses such as India to control what is in the media. We need to put a stop to this. And the only way we will do it is from the ground up. And therefore, I would encourage you to continue using your platforms. Everyone on this video call and everyone who will watch this specific intervention has access to some kind of platform, be it Twitter, Facebook, Instagram. Continue to share information. Let us dispel fake information and fake news that continues to fill and flood all of our timelines. We need to all be activists from where we are. The first speaker, the professor, first mentioned that the use of correct maps, and this is vitally important. In my fight and our fight for Western Sahara and the self-determination of the Sahrawi people, maps are incredibly important. Every time we see an incorrect map that is either up on a wall or is printed somewhere, we need to take action. We need to ask for the removal of those incorrect maps. We need to make sure that we're putting out the correct information that the world needs to see. We need to be ones that are telling the stories, because if we continue to wait, as mentioned, this is the longest protracted occupation in modern history. How can it be that this continues to happen? We can send a man to the moon, but we are unable to ensure the inalienable right of self-determination for the Kashmiri people, for the Sahrawi people, for the Palestinians, and the list goes on. So I would encourage you all to continue being activists from the corners that you live in. It is important that we keep constant communication. We need to ensure that we are communicating correct information. We're using the WhatsApp groups that are available to us to constantly share news that goes out with a broader spectrum of people. Let us widen our circle. Let us ensure that the next time that we meet under this wonderful forum, and to the organizers of this forum, I thank you. Shukriya, this is so important, but let us continue. Let us do this again in some weeks' time, but let us make sure that we have expanded this specific platform. As an activist who fights for human rights and social justice, it is important for me to see that more people know about the Kashmiri conflict, that more people are aware. It must be that when people see a news article or paging through a newspaper, depending on where in the world you are, there should be a column that talks about specific issues. You are on the ground and need to tell your stories. And as an activist, I would encourage that, because I can only learn from you to be able to do so much more, to use the platforms I have to continue working and fighting and bringing life to the specific issue. There are the legal issues, the political issues, and the political issues need to be at the forefront and need to be what we push when we're sitting at the UN Security Council, when we're sitting at the UN Human Rights Council in Geneva. But more so, we need to ensure that each and every one of us has this information at the tips of our hand, that we're able to share and disseminate facts, figures, understanding what is happening. It is only because I've sat in those rooms at the United Nations and sat in the Human Rights Council for so many years that I've understood and seen the violent conflict of Indian occupied Kashmir. I have seen for myself, I've been to Azad Jammu Kashmir, and I've seen there what is happening. I've seen how the Kashmiri people there live much in a safe environment. They're protected. I felt safe. I was not threatened once. I did not feel like my life was in danger or in harm. I understood because I sat and lived with the people on the ground. I sat with generations of families who have been outside of, contact with their families in Indian occupied Kashmir. They cried and they broke down when they could not explain in words the feelings of the torture that they could not make contact with their family that were in Indian occupied Kashmir. The amount of lives that have been lost are far too many. But it is up to us to now be the voice of reason, to share what we know because we have been there or because we have heard the stories firsthand. So to each and every one of you who has continued to be a part of this platform, who continues to bring voice to the Kashmiri conflict and issue, I applaud you and I ask you to continue doing this hard work. Many of the people on this call know a great deal more than I do. And as the speaker before me said, he's only just a student still, as am I. But I'm a student willing to learn, to listen, and to grow with this information, and to use the platforms I have available to me as an activist and as a global figure who is given international platforms. Let us continue to give voice to the absolutely horrifying realities that continue to happen in Indian occupied Kashmir. To those who are on the ground and who continue to suffer every single day, we keep you in our thoughts and prayers. And inshallah, one day this will come to an end. In our lifetime, we will see justice. We will see that this conflict is one that we talk of in a past tense, in a history format, where we are able to talk of the work done by the martyrs of the Kashmiri people. Shukriya.
Thank you very much. Thank you for inspiring comments. We owe a lot to you, Ms. Catherine. Thank you once again. So formally our session is end. So I would request all our participants, if they have questions, a quick 5 questions we'll be taking. If they have questions, please raise your hand, or we can keep a mic open for them. If any question for our distinguished guests, especially Raja Sajad and Ms. Catherine is here. Earlier, I have received 3-4 questions, but I guess they were for Professor Sikandar Shah. So one more question is, how should Kashmir be given observer status at OIC? Ms. Catherine, is one question.
Okay, thank you. I think I'm unmuted now. Just very quickly on the observer status, it is important. The observer status is something that is very difficult to obtain, but it needs to be obtained via forums or civil society movements that exist. If you have your paperwork, I would insist and encourage you to set up observer status. It's a long process. Go through that process, let them turn you down, continue. Ensure that you try to, through your organizations or NGOs, human rights bodies, whatever it might be, try to get that observer status. It is very important, and it's something that we need more people who are lobbying specifically on the Kashmiri issue. We need them to be more participative in these environments and within these forums. These forums don't always bring us what we need, but unfortunately we need to be inside of the system to be able to bring about change. Somebody else also mentioned within the comments and made a very important comment around scholars and the coordination of scholars. This comes from Raja Khan. We must explore new avenues of collaboration, collaborative efforts across regions, across universities, across NGOs, different civil society movements. Collaboration and coordinated efforts are extremely important, and there should be several coordinated efforts when we talk about international solidarity campaigns around the issue of Kashmir, and we must ensure that we do all that we can to connect with each other and to make that possible.
I would like to ask a question, if that's okay. Thank you. First of all, I would like to say thank you so much for all our speakers today. It was quite a spectacle to hear you guys speak. Ms. Catherine Constantinides, sorry if I'm pronouncing your name incorrectly.
That was perfect.
I read, I've read about your work, and your portfolio is very impressive as an ambassador for South Africa and taking up the case of Western Sahara. I wanted to ask you, what is, in your honest opinion, the reason for how in these ambassadorial roles, Kashmir has been eluded by many activists and international, in general, the international community as a whole. What could be the reason for? Is it the mistakes of the parties concerned, or the people that have been perhaps projecting the issue correctly to the world?
Afzal, thank you for the question, and it's an important question. I would not know the specifics around these global figures or potential candidates who have been kind of brought in to speak and to be ambassadors for this issue. However, I do think that the one thing that becomes a really, really important element moving forward, I can't speak for the past and for people the Kashmiri people have worked with in the past, but moving forward, I think the most important thing is to be able to drive awareness and education. Not enough people truly understand the conflict of Kashmir. Not enough people understand the political role players within the space. And I think that a lack of information and education outside of the academic arena, sometimes people get overwhelmed by the academics of it. The politics of it are shared in such an academic way that people, you almost miss connecting with the people. You almost miss being able to express to them from person to person what this conflict is actually about. I had the privilege of going to Kashmir. I had the privilege of engaging with Kashmiri people across generations, young people at the University of Kotli. I spent time with older generations of people who were out in the mountainous areas, and it was a great privilege to listen to them, their first-hand experiences, because reading a book or reading an online article, I could not have understood their pain and struggle in the same way. But what I do now have is the opportunity to share their struggle, their pain and their suffering, because I was able to connect with them person to person. So when I go out, and as I mentioned, as a human rights defender, my work has really been because I understand an issue or a conflict, because I've been there myself. I try to learn as much as I can from the people that I'm working with, never to replace their voice, but to be a voice alongside with them. And working with the Kashmiri activists at the United Nations over these many years, I've had the privilege to be able to learn from them. And constantly I'm a student in this specific field of the conflict of Kashmir. And each and every time I engage, I'm engaging in order to learn. But I think that education and actually the fundamental issues of why there is a conflict in the first place, what happened, where other role players such as the United Kingdom played a role many, many years ago in the divisions and geographical divisions that they brought in. All of those elements, all of those pieces of the puzzle need to be put down in a way that people understand, but they are not overwhelmed. Because people who are not in the human rights space, are not in the justice space, sometimes become overwhelmed by the academics and the politics of an issue that they almost withdraw. So I would really say it's really about education and awareness and having those one-on-one conversations. I have no doubt that the world at large would be horrified at what is happening in Kashmir, but they're just not aware. And often, and even on the issue of Western Sahara, I always say, and this stands true for the issue of Kashmir, people don't know what they don't know. And so they're not looking for information on Kashmir because they just don't know what is happening on the ground. And so even when, the organizers for today reached out to me to be a part of this, I was so grateful that they sent me that direct message on Twitter. They connected with me. When you tag me in things that I can share with a larger audience, I want us to be able to engage moving forward. I don't have all the answers, but I am certainly on a journey learning, growing, and ensuring I do all that I can, because this conflict should not continue. And for it to be the longest conflict in modern history is unacceptable. This is something we should be ashamed of as a generation and as a global community that continues to push forward to make strides in humanity. Yet this issue still continues in our lifetime.
Thank you so much.
Very much. Thank you. Now I invite finally Mr. Riyal Khalik for his remarks. Mr. Khalik, if you can hear us, please.
Good afternoon, everyone. Once again, thanks to Legal Forum for Kashmir that we need as much mouths as many to speak, talk, and discuss about Kashmir. Can you hear me?
Yes.
Fine. And thanks to all of the three speakers. Personally, I would like that whenever we invite a speaker, please ensure that the participation remains until the end. I believe that you do invite speakers with, they are informed well before in time, so it should it sends a very strong message. Participants remain focused and everything. While I heard Catherine, very nice, and it's very rare, despite the fact that South Africa has a very strong history of resistance, but with vis-a-vis Kashmir, it's very rare that we get to hear, although there are many groups working on, but not the way it should have been, like we see in UK or for that matter in US. We have many things to learn from the history and the resistance movements in South Africa. But nevertheless, thank you very much, Catherine. It is now the fourth conversation on the topic international armed conflict in Kashmir. To be very honest, such conversations set the agenda, and they are very important. And today, Mr. Khan raised this issue that whether Kashmiris should be given representation at the multinational blocks, especially when starting with Muslim blocks, and of course we have OIC there. These things, the responsibility for such conversations must have been held in past as well. But these things, I think Islamabad need to take into consideration that at a time when when China imposed this national security law in Hong Kong, all the Western capitals which boast of democracy and regard for human rights, they imposed sanctions, they withdrew from many agreements with Hong Kong, but it did not what India did on August 5 by locking down 8 million population. That move did not invite such reaction. And it has been over a year now. We again saw NGA meeting, but there has been no change on ground in Kashmir. So what is the way forward after making such hue and cry, after utilizing all its resources? What is the way forward on Kashmir? Those topics, that issue, our focus now must turn to that after using Pakistan as a state, using all its resources and energy on forcing India to revert to pre-August 5, 2019 status, appears to not have achieved any result. So what should be the way forward now should be, I think, our future conversations. And of course, I mean, with focus on legal aspects of the dispute, because at the end of the day, if one has to hold people accountable to the crimes they have committed, these things are very important. Second, third one, that what we are now of late, there has been a debate has started on Pakistan granting the provincial status on Gilgit-Baltistan. So that is one of the very important issues that needs threadbare discussion. And I believe with legal human resources at its disposal, LFVOK will pick up debate on it, and let us discuss, talking to people in Kashmir, talking to people in AJK, talking to people in Gilgit-Baltistan. Let us listen to what people in GB want and then put it into the mainstream narrative building. Thank you very much for the time. I learn much from these discussions, and it's not necessary that every time we speak, but yet, thank you very much.
I'll add something to Mr. Khaliq's comment. Mr. Khaliq, the purpose of conducting 7 series of webinar on international armed conflict and Kashmir is it includes every part of the Kashmir under the United Nations Security Council resolution, that we believe that Kashmir is merely not a territorial dispute, nor it is a civil war or strife, whatever you all, the myths which India is saying that it's internal matter. Kashmir is one of the ugly, hostile conflict which comes under the ambit of international armed conflict under law of war. So it covers the entire things. We'll be discussing the status of every region, I mean, attached to it, be it Gilgit-Baltistan or Azad Jammu Kashmir, and then occupied Kashmir. You know, the position, the status, why the things, especially the illegal annexation and the changing of the demographic area in the occupied valley, constrained us to have these webinars, what is the status and why the humanitarian attitude when it comes to the Syria, Yemen, or Palestine. So our purpose is to tell to entire world community as well as to the humanitarian agencies. This conflict will take it will take much more lives if not addressed at place. I once again thank you everyone. Thank you Professor Shah, thank you Professor Sami, thank you Ms. Catherine. It was too inspiring. Thank you Raja Sajjad Khan Sahab. So with this we end, and please stay tuned. We'll be shortly with our 5th series of the webinar on same topic, international armed conflict and Kashmir. Thank you very much. Assalamu alaikum wa rahmatullah.